Good evening, AP Gov students. This is your last Federalism lecture before the exam on Friday, and by the looks of things, not a whole lot of you are watching this, so I hope today's pop quiz changed your tune a little bit, and you're tuning in for some information on federalism in the courts. This is a crucial lecture because it'll help us understand the healthcare debate we're doing on Thursday, and this seems like a perfect topic to bring up on the AP exam. All right. So when we look at federalism in the courts, this is usually where the disputes get settled between the states and the federal government. And I'm going to go over a number of cases with you that kind of have relevance and have changed the way we interpret the document and therefore federalism. The first sort of wave of things, the courts have really been nation-centered, meaning they focused on a strong central government and supported an expansion of Congress's powers. And we see a shift under Chief Justice Roger Taney from the Dred Scott decision all the way up to the New Deal, where the states start to have a little more power than the federal government does. Then we see a constitutional revolution in 1937, beginning with the New Deal and a couple of key cases we'll go over. And then in 1983, we see a big shift that's, for the most part, still with us today, with a few exceptions, but we shift back to the states again. So it's kind of a pendulum back and forth between nation and then states. All right, so let's follow along the timeline here on the next page. All right, so 1819 is your first real federalism case. Most of you remember this from AP US history, McCulloch versus Maryland. You're probably thinking National Bank. And this usually makes the AP exam. This is one of our top 6 cases. You'll definitely have to know. Essentially, in this case, the federal government had created a national bank, and it was rechartered by James Madison. And some of the Democrat Republicans and small government advocates did not want the bank. So in Maryland, they put a tax on the bank to prevent it from existing, essentially, hoping they could tax it so it would not be profitable to have a national bank. And the Supreme Court ruled 2 things in this one. They ruled, number 1, that Congress has implied powers that are not mentioned in the Constitution, and that's through the Elastic Clause, Article 1, Section 8, Clause 18. That's the necessary and proper clause. It says Congress can create a national bank. It's an implied power because they already have the enumerated power to coin money. So therefore, it's implied that they can create a national bank. The other thing they implied was that the Supremacy Clause says that an act of Congress is supreme to a state law for that one. All right, Gibbs versus Ogden is our next case. And you're probably saying steamboats. Well, if you say steamboats, you're on the right track. For this one, Congress ruled that, or Congress had passed a law essentially eliminating a monopoly that a steamboat operator had between New York and New Jersey. And Congress wanted to let other people navigate the Hudson River. And the Supreme Court said that Congress has the power to regulate interstate commerce. So the fact that that steamboat went between New York and New Jersey meant that that was up to Congress, not New York. So it took his monopoly away on that one. So Gibbs versus Ogden is the Commerce Clause. McCulloch versus Maryland is the Elastic Clause and Supremacy Clause. All right, fast forwarding to 1873, we have the Slaughterhouse Cases down in Louisiana, which dealt with some Reconstruction issues and the interpretation of the 14th Amendment. And making a very long story short, the slaughterhouses in Louisiana were shut down due to their lack of cleanliness. We won't get into the details of that. But the owners of the slaughterhouses sued, saying that the state took away their life, liberty, and property without due process, trying to argue the 14th Amendment applied to them. You're probably wondering, 14th Amendment, that's Reconstruction. Okay, well, you're correct. And that was supposed to help African Americans, not slaughterhouse owners. And that's exactly what the court said. And they kind of narrowly interpreted the 14th Amendment to say that we're only going to protect African Americans with this, and it does not apply to businesses or individual that are affected by state decisions. It only applies to African Americans. So it kind of limited the powers that the federal government had there. All right. Now, our revolution here begins in 1937 with FDR. Now, most of you remember court packing from U.S. history last year. Some of you may not. What basically happened is the Supreme Court, all right, as we know, has 9 justices. All right, so we have 9 justices on the court. And Roosevelt was losing his key decision 7-2. All right, basically out declaring a lot of his policies of the New Deal unconstitutional. So Roosevelt comes up with this genius plan to kind of get around the Supreme Court, and he says, I am going to propose 6 new justices to the court, which he would be able to appoint, all right? And then the 7-2 rulings that were declaring all of his policies unconstitutional now become 8-7, because those 6 justices are going to rule in favor of FDR. And he basically is going to get around the Supreme Court. Now, he's doing this because he's sort of taking this gamble that the public loves me. I've been elected to a second term. We're solving the Great Depression. I'm trying to help people out, and the Supreme Court keeps getting in my way. Well, Congress steps in and says, well, we're not going to allow this court packing. That's kind of our job, and this kind of oversteps your bounds a little bit. But in doing that, Roosevelt got public opinion waged against the Supreme Court to the point where people weren't even going to take them seriously and start not supporting their decisions. So Roosevelt kind of wins the public opinion battle, and the Supreme Court, not wanting to sort of lose face, starts to find ways to approve his policies. So the first case after court packing, all right, was NLRB versus Jones Laughlin Steel. All right, and this actually dealt with the right to form a union, not minimum wage that you see here on the board. Ignore that minimum wage. It's kind of a complicated case, but essentially the court said that Congress could protect labor unions under the Wagner Act, one of FDR's signature policies of the New Deal, because the Jones Laughlin Steel Company was partaking in interstate commerce. They were buying and selling things across state lines, so Congress can regulate it, protecting labor unions. And the NLRB, ironically, is in the news this week because of Obama's appointments to them, which, again, he wants to appoint pro-labor union people. Conservatives want anti-union people on there. So this issue never really seems to go away. Now, a more interesting case that kind of explains this a little bit better is Wickard versus Filburn. Now, this is probably never going to make an AP exam, all right? But it really helps show you how Congress said, well, all right, FDR, we'll buy into what you're trying to do, all right? So let me get another color up here. All right, we'll go with green. All right, now this challenged the AAA, Agricultural Adjustment Act. I'm going to write an A on here 3 times so you know what we're talking about. All right, now the AAA was done to protect farmers, and they proposed a policy because they wanted to limit the supply of the crops. So they told farmers you can only grow X number of acres. All right. So Farmer Filburn, all right, had a farm in upstate New York and was only allowed to grow 150 acres of crops. Okay. Well, Farmer Filburn didn't like that because he wanted to grow more. All right. Anything over that you would be fined, because what we're trying to do is limit how much farm products are in or crops are in circulation, driving the price up. So Farmer Filburn says, I'm going to take 3 extra acres of my property over here, all right, and grow extra feed for my cattle and my hogs, all right. And his argument was, well, Congress can't regulate that. I mean, I'm growing it in New York, I'm feeding my hogs in New York, and I'm selling them in the New York market. No interstate commerce. Congress has to leave me alone. So AAA comes in, all right, or the government and Department of Agriculture finds Mr. Filburn, says you can't do this. So he takes his case all the way to the Supreme Court, and the Supreme Court, kind of knowing, well, God, we got to support FDR's policies, they say, well, Mr. Filburn, you might be correct that you're growing corn to not be sold on the market. It's not interstate commerce. However, all right, if you were following the rules that the AAA set forth and only growing 150 acres, you wouldn't have anything to feed your cattle. So you would have to then go buy corn on the open market and feed your cattle. And since you'd be buying on the open market, you would be engaged in interstate commerce if you were doing what you're supposed to be doing. So therefore, the AAA can regulate what you're doing. Congress is okayed under the Commerce Clause to regulate your business. Now, this is actually one of the precedent cases for the healthcare case, arguing that not getting insurance is interstate commerce and Congress can regulate it. So the court got very creative, to say the least. All right, this will come back and talk about marijuana here shortly. All right, 1964, Civil Rights Act of 1964. Crucial law, one you will have to know. It will be on Friday's exam. All right, the case was Heart of Atlanta Motel versus United States. A gentleman in Atlanta owned a motel, and the Civil Rights Act ended discrimination in public accommodations. So the law basically says you have to allow black people to, or African Americans, to attend your motel. This person sued under, believe it or not, the 13th Amendment, arguing that it was involuntary servitude to have to take in black customers at his motel. You can imagine the Supreme Court kind of laughed, but they did take the case, and they ruled 9-0 that the Civil Rights Act did not violate the Constitution, because, you're probably figuring this out by now, if I live in Chicago and I'm taking a trip to Atlanta, I'm taking my Illinois money, bringing it to Georgia. Therefore, it is, you guessed it, interstate commerce, and Congress can regulate it. So commerce, the Commerce Clause, expanded civil rights. That was how Congress was able to pass this law and get around the courts and things like that. So the Commerce Clause has been used to expand civil rights. All right, moving ahead to U.S. versus Lopez. Now, this is the first case since the New Deal to limit the Commerce Clause. All right, you're going to read this for homework tonight, so you've probably read it already. This case involved the Guns-Free School Zone Act in Texas. And in the Guns-Free School Zone Act, you were not allowed to bring a gun within 100 feet of a school. All right, this was pre-Columbine, ironically. And Mr. Lopez brings a gun to school. All right. Now, he doesn't sue under the Second Amendment. All right. He's not challenging his right to bear arms. He's saying that Congress doesn't have the authority to tell me where I can bring a gun, because when Congress passed the law, they said, well, this is interstate commerce. We're regulating it. And the Supreme Court ruled 5-4. It was a very narrow decision, all right, that bringing a gun to school is not interstate commerce, because he bought the gun in Texas, he owned it in Texas, he went to a school in Texas, no interstate commerce. So for the first time since 1937, where Congress had been really loosely interpreting the Commerce Clause, the Supreme Court says it has to actually be commerce. There has to be something bought and sold across state lines for Congress to regulate it. So it's really a win for the Republicans and the small government people. All right, U.S. versus Morrison. It was the Violence Against Women's Act. Now, how is a Violence Against Women's Act unconstitutional? All right, well, let's take a guess. All right, the Congress passed the law. Where in the Constitution does it say they can protect violence against women? It doesn't, so it's reserved to the states. All right. Now, it's not an implied power. It's not under the Elastic Clause, because the Elastic Clause, going back to McCulloch versus Maryland, says for the Elastic Clause to apply, it has to be something that Congress has an enumerated power to do. So the bank is an implied power based on the enumerated power of coining money. All right. So the Violence Against Women's Act was passed saying, well, this affects interstate commerce. If a woman is abused, she might move from Illinois to Wisconsin to get away from her husband, so she's going to buy a house. That's interstate commerce. Supreme Court said, sorry, this law, believe it or not, was unconstitutional because violence against women was not interstate commerce. All right. Our final one here is Gonzales versus Raich. We will discuss this in class. You're reading it as well. And then Gonzales versus Oregon. Both of these deal with the Commerce Clause. And Gonzales versus Raich upheld Congress's limitation of medicinal marijuana because it was interstate commerce. Even though you can't buy marijuana in California, you would have to buy it in the open market in Texas, so they cited the Wickard versus Filburn case. I think I'm out of time on this one, and I apologize for ending this a little too early.